Hi, everybody. This is Jeff Fowler, president of the Apartment Owners Association. It's great to have you with us today. And many of you may have heard the news from last week about there's a couple cases from New York City that went all the way to the Supreme Court, and then the Supreme Court decided not to take those. And anyway, so today we're going to have an expert come on all the way from New York and who's with Pacific Legal Foundation. But before we get into that, AOA has been around for over 40 years. It's specifically for the state of California. And for $97 a year, you get access to state and local forums and our property management advice helpline, the magazine, wholesale tenant screening, the highest quality you can get, and so much more. So much more. And anyway, there's a whole lot that is going on. And even with just this next month, we have a lot of in-person events. Last week, had a great time at the San Jose Bay Area Landlording Power Conference that we put on. And we're going to put on a San Diego Landlording Power Conference in May. But before we get to May, in March 21st, we have the AOA $1 Million Trade Show and Landlording Conference. And that's going to be held at the LA Convention Center. And so if you're able to make it, we want to encourage you to go to that. There'll be over 150 different vendors that are there. We'll have over 20 seminars, and it will be fun, and even more fun than normal because we will have a virtual golf simulator that's there to raise money for the AOA Political Action Committee. And many of you know that there's on the ballot this year in November will be the Justice for Renters Act, which will try to repeal Costa-Hawkins, and that is a big deal. And we have to stop that, or the consequences will be losing the ability to raise your rents to market rate when tenants move out. So different municipalities could enact vacancy control and really just entirely wreck the industry for both residents and owners. And so anyway, besides that, on the 14th of March, we have in-person in San Diego conflict resolution skills for owners in dealing with their residents. And the 26th in Fremont, we have a 12 Pillars of Property Management course that will happen. On the 28th in Oakland, we have a doubleheader. It will be understanding the eviction process, and then also an asset protection speaker will be there. So there's a whole lot. Sometimes we put stuff out on YouTube without making an event out of it. So you may want to subscribe to the YouTube channel, AOAUSA.com. And just to get into it here, our speaker today from Pacific Legal Foundation. And if you don't know about them, look them up for sure. They are fighting for property rights so often, among other things. But our speaker today, he had his own practice for 17 years defending property rights of owners and housing providers. And then since 2022, he started working with Pacific Legal Foundation, and specifically in the area of property rights and regulatory takings. And so often we get that question about, well, isn't this a takings? And so we're going to get into it today. So it's my pleasure to introduce our speaker today, Jon Houghton.
So good afternoon, everyone. Thank you very much for having me today. Thank you, Jeff. I really appreciate it. Pacific Legal Foundation, for anybody that doesn't know, we're a nonprofit, and we actually started back in 1973 fighting for property rights for property owners from California. So you collectively, all of you, you are the owners that we have been fighting for 50 years now. We just celebrated our 50th anniversary. And the focus of PLF, and my focus too, obviously, is to take these fights on behalf of property owners to the Supreme Court. It's something that we've been tremendously successful at. So far, we have taken 19 cases up to the Supreme Court, and we've won 17 out of the 19. We have another case up at the Supreme Court right now that we're waiting for a decision on. We won 3 cases in the Supreme Court last year. So fighting on behalf of owners like you, and specifically a lot of owners in California, is something that we've been doing and doing well for a very long time. So I just want to say thank you to Jeff, and thanks for the opportunity so I can talk to everyone and let you know about the New York rent control case and what it said and what it's about and what it holds and kind of how it bodes for the future. And also, what I'm going to go through a little bit too is what these cases are about and what the law is. Because I think that's one of the confusing things. And for all of you as owners who have your own properties and your own rentals and your own apartments, to sort of understand where the law is and what you can do about it and how you can help resolve it, I think is also really important. So, getting to these cases, this last term, there were 3 cases from New York, all at the same time, that applied to the Supreme Court to be heard. And essentially, the way the short version works is that about 7,000 applications come in a year. They're called petitions for a case to be heard in front of the Supreme Court, and they only take about 80 to 100, depending on the year. So these 3 were amongst the many. But they garnered a lot of attention and a lot of thought because rent control is obviously something that's important. It's something that's been on everybody's radar for a long time. And the court took a really, really long time to consider this and to think about it. And even though they didn't take it, we did have a little bit of insight in terms of how they denied it, for what this bodes for the future. So all of these 3 cases stemmed from the New York rent control law that came about in 2019. I'm a New Yorker, so I'm actually well familiar with this. And even though I am not a fan of rent control, it did not prevent me from living in a rent controlled apartment for a period of time in Brooklyn, because why not? But New York's rent control was originally like a lot of the other rent controls around the country and similar to a lot of the ones in California. But what happens, I think, with most rent control is it eventually, and everybody knows this, eventually your property is going to be upside down. And that's just the way it is, because at the end of the day, when they cap your rent, but you have expenses and repairs that have to be made and capital improvements and inflation and all those other factors, and increasing insurance and increasing property taxes, ultimately there's going to be a point in time where it catches up and the property becomes upside down. So in New York, the way it always was there were a lot of loopholes. Some above the board, some below board, some they kind of looked the other way on. And in 2019, they decided to close a lot of the loopholes, which made it tremendously, tremendously difficult for property owners in New York City. And just to show sort of how backwards rent control is, I think everybody probably knows this intuitively or just knows it themselves. When you implement rent control, what it actually does is it results in less apartments on the market, because rent control is in the end not economically profitable. And since this law was passed in 2019, there have been estimates that anywhere between 80 and 100,000 units that were rent controlled are now warehoused or off the market. But in any event, what the New York rent control did in 2019 was, always there was the rent cap, and they obviously kept the rent cap in place. There also is a mandatory lease renewal that, unless you have cause to evict someone, it is mandatory that property owners offer a lease, either a 1 or 2 year renewal. And the really important part is they took away all of the exemptions. So the way it used to be was that if rent hits a certain amount, hits a certain number, then your property can get decontrolled and it gets out of rent control. You increase 3%, 3%, 3%, 3%, and then you hit a certain number and then you're out. They got rid of that. There also used to be an exemption where property owners could take back not just one unit, but multiple units for family members. They changed that and then they said, well, now it can only be one unit and you have to show an immediate and compelling need why you need that one unit. Property owners in New York could still do for-cause evictions, but the 2019 law allowed a judge to stay a for-cause eviction for a year, which is just dumb and defeats the purpose. You could be able to, property owners used to be able to get, I wouldn't say great, but a moderately acceptable percentage of capital improvements back and roll those into the rent. A lot of those went away. Let's see what else. It used to be that if you had a high income tenant, you could take it out of rent control. Obviously, there's no sense having a rent controlled apartment for somebody earning $1 million a year. That went away. And last, you used to be able to decontrol your rental building by converting it to condos or co-ops, and that went away. So the combination of all of those had a tremendously detrimental effect on rent control owners. And here's I guess another fun fact just to sort of show what the market thinks of it. A lot of the financing for these rent control apartments went through one particular bank in New York City called Signature Bank. And Signature Bank had a lot of difficulty and was starting to go under, and they got taken over by the federal government. Federal government took over their loans. They wanted to unload them, and they would have a percentage and then unload them to private investors. Signature's loans for regular, I guess, regular normal apartment buildings was fine. All their commercial loans were generally fine. But for rent-regulated apartment buildings, nobody wanted them. They kept trying to auction them off and nobody wanted them. And ultimately, they got somebody to take them. But I think there was only one or two bidders, and I think it was... I forget what the discount was, but it was decent. It was something like a 40 to 50% discount on 5% of the loans, with the federal government keeping the other 95%. And I just mentioned that because I think it reflects what the market thinks of rent-regulated properties. Because, the market as a whole understands that ultimately these properties are going to be upside down. So now the key is trying to bring the court along and to get the court to understand why this is problematic, why they need to take a look at it, why this is actually detrimental to housing, because it actually results in less housing over time. So these three property owners, three separate lawsuits, they all started in federal court in New York, and they all went along a predictable path. They were filed in federal court. They had their lawsuits dismissed by the federal district court judge. They went up to the appellate court, the federal appellate court, which is in this case the Second Circuit. The Second Circuit said the same thing and threw them out too. And to the Supreme Court they went. So this is where we're going to, I'll get into a little bit of a regulatory takings tutorial so you as owners can understand what the law is, what your rights are, and attacking rent control and attacking these type of cases, what the legal side, what us property lawyers are thinking about and what we're aiming for these type of cases. So property in general is one of those things that has always been a little hard to define, particularly from the Supreme Court. What is property? What does it count as? But essentially what they've said is it comes down to three basic rights. One is you have the right to possess and exclude people from your property. That's one. Two is you have the right to use your property for an economic benefit. That's two. And three, you have a right to sell it, to alienate it, to give it to your family, pass it down in a will, whatever have you. Those are the three rights: to possess and exclude, to use, and to sell. So anytime there is a government regulation that takes one of these rights away from you, the Fifth Amendment of the US Constitution requires them to pay for it. And they have to pay you the fair market value, which is what's called just compensation. And in a lot of ways, it's not that much different than eminent domain, which people may sort of generally be familiar with. Eminent domain is where the government may come in and take private property to build a school or a road or a government building or a police station. They can do it so long as they pay for it. And a regulation is really the same thing. The difference is, because it's a regulation, the property owner has title. But if this regulation takes away your right to possess or exclude, or your right to use your property, or your right to sell your property, then it's what's called a regulatory taking. And under the Fifth Amendment, the government has to pay you just compensation for what they've taken away. So for these New York rent control cases, here's what everybody argued. There were two basic claims for two different parts of these property rights. One is a physical taking of the right to use. I'm sorry, a physical taking of the right to possess and exclude. So one, you have this right to possess and exclude. You can possess the property you own and you can exclude others from it. So all of these owners focused on mandatory lease renewals. And they said, look, we should be able to take possession of our property when we want to, and we should be able to exclude other people from the property when we want to. And yes, we have a lease, but if we want to have a lease expire on its natural terms after a year or 2 years or whatever, and have our property back, you should let us, because it's our property. And you can't force us to house people against our will. Even if those people are paying rent, our right to possess and exclude means that you can't force us to have our property be occupied when we don't want it to, because that's our property. So that was one. The second one was in the taking of the right to use. That one's always a little dicier, because the right to use, what it actually is, hasn't really been defined that well by the Supreme Court. So it's always difficult to figure out when the right to use has been taken, when the right to use hasn't really been fully defined to start with. It always kind of makes it a little backwards. So what the court did a while ago, from a case stemming from New York, is they did this 3-part test called Penn Central. And they look at what is the economic impact on the property owner, and what is the impact on their reasonable investment-backed expectations, and what's the character of the regulation? What's the burden? Is it something that you're putting on just a couple people, or is it something that you're putting on everybody under the sun? And how is that burden sort of shared amongst the public? So that was the second part of what all these owners did for the New York rent control cases. They said, look, by capping our rent, you're taking our right to use. our property is ultimately going to be upside down, and it's a taking of that right too, besides the physical taking. So these cases all went up to the U.S. Supreme Court, and they were going they were there for a while. I think they got filed in September, I want to say, and the Supreme Court finally said no recently, about a week and a half ago. What's interesting about it for me is the way in which they said no, because what the judges can do is, sometimes they'll just say nothing, it's denied. Sometimes they'll write on it and say, well, here's why we're not taking it. And in that, Clarence Thomas wrote something, which is interesting and helpful and not helpful, but gives a little bit of insight into where they are. So he did not want to take this particular case, but he did give a little bit of a roadmap for future cases. The first part of it, with respect to the right to use, this is that 3-part test: economic impact, investment-backed expectations, and the owner is saying, well, we can't make money because of the rent cap and our property is going to be upside down. He actually didn't say anything about that at all, which, to be honest, I find a little unfortunate. It makes me wonder if rent control is a little bit of a third rail and they don't want to get into it, but I'm not certain. I wish he would have said something about it, but he didn't. What he did say was he talked about the physical part of it, that this is for the mandatory lease renewals, that you can't kick anybody out and you have to keep renewing the lease forever and ever and ever, no matter what. What he said was, well, for this case, we're not going to take it, but here's what I'm looking at for future cases. For future cases, if you want to attack the regulation as a whole, meaning this regulation is unconstitutional against every single property owner in the state or in the city, wherever your locale is, we need to have a clear understanding of how this regulation completely bars people from evicting tenants. And in these New York cases, we don't have it. So we're not going to take the New York cases. And if you're not claiming the whole statute is bad, but just for you, for your one individual property, it's a physical taking and it's unconstitutionally affecting you as a singular owner. Justice Thomas wants to know how the specific regulations prevent you from getting an actual tenant out for a very specific reason. I need to get this specific person out, and here's why I can't. And he said that is also not in the New York cases, so we're not going to take them. But he tried to give a little bit of a roadmap. Overall, I have to say that I found it insightful but not helpful. It was nice of him to share, but I would have liked to hear something about why the money part of it, why when rent control can put your property upside down, what he's thinking about or what the court is thinking about for that. And in terms of what he's looking for this specific tenant has violated this specific rule of the lease and I need to evict them for this specific reason and here's why. I think that it is not necessarily the most practical thing for you actual owners on the ground. I mean, of course, if you want to evict someone, you have to say that and you want to go through the eviction process. But you as the owners don't want to have your eviction case go up to the Supreme Court. You would like to have your eviction case resolved so that your tenant who is defaulting on rent is out and you can then re-rent it to someone who's actually going to pay the rent. And you should not have to do that to take that case all the way to the Supreme Court and spend all that time to get there. So I understand what Justice Thomas is asking for, but for practical purposes, it's not the most helpful thing on the universe. But that's where it is. So for us, and at least for me and for Pacific Legal Foundation going forward, obviously, I'm decidedly not a fan of rent control. I am decidedly not a fan of mandatory lease renewals. These are both things that and issues that we want to take to the Supreme Court and take up and get rid of. And for myself and for us at Pacific Legal Foundation, we're going to keep banging on the Supreme Court's door and fighting the good fight until they take it. Because for better or for worse, a lot of times that's what it takes. And just to give everyone an example, for these type of cases where it's a regulatory taking, the government issued some regulation that takes away one of your property rights. You used to not be able to go to federal court. You used to always have to take that to your local trial court, your local state court. And that was wrong because it's a federal constitutional violation, but there was a Supreme Court case that said you couldn't, and we wanted to reverse it. And ultimately we did in a case called Nick, but I don't know how many petitions we filed to Supreme Court before they finally said yes, but it was somewhere in the neighborhood of like 8 or 9, maybe a couple more than that. And there's another thing that everybody probably is really familiar with, particularly if anybody has done any development, is the local government quid pro quo. If you build this development if you want to build this development, I will give you your permit if you give me X. And a lot of times, depending upon what they wanted, it could be unconstitutional. But what government started doing was not doing that on an individual permit by permit basis, but actually building things into the zoning code that I know everybody's familiar with. Like impact fees. If you want to build, you have to pay X to build. And what we at Pacific Legal have been saying forever is that is just as bad as on an individual permit by permit basis. You can't have a quid pro quo. And we were sending that up to the Supreme Court many, 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 many times, and they always said no until they didn't. And this year they finally said yes, and they took a case called Sheets, which was also brought by us and Paul Beard, who's a fantastic attorney in California, and used to work for PLF. And, I don't want to jinx it, but we're feeling good about it. So I guess the point is that when you're trying to fight these fights and trying to have an impact on constitutional law and take cases to the Supreme Court, sometimes you just have to bang on the door over and over and over and over and over again and have persistence and have faith and know that you're right and keep fighting that fight to get those cases there. And even though these particular cases for New York and rent control didn't work, we'll keep doing it. We weren't a part of the New York ones, but it's certainly something that we want to do, and we'll keep doing it, and others will keep doing it, and eventually the door will open. We just have to sort of keep at it. So I think that's all that I was going to go through with respect to the New York cases. But if Jeff has any questions or anybody else has any questions, I'm happy to.
Great. Thank you so much for sharing. We'll open it up to questions now. So if you're on YouTube or Facebook, you know what to do. If you're watching from the website, there's a blue chat button at the bottom. And if you type your question in there, they'll be able to get that over to me, and then we can ask the question. And so you had mentioned like Paul Beard, he's the attorney that we use most of the time. So we know him, and he
Paul's
like,
amazing.
yeah, he is absolutely. And what was it about? Can you mention that what you have going on there with that, and give us a little more information on that?
Oh, yeah, no, absolutely. So, what the way the law is, it essentially is there's a doctrine of law called unconstitutional conditions that prevents the government from doing, really improper quid pro quos. You give me this and I'll give you your permit. And the Supreme Court cases that came around all said that you can't do this, but they always looked at it as an individual basis. You apply for the permit and your local zoning board or, building department says, give me this. So what a lot of municipal governments started doing was saying, oh, well, all right, well, we're going to take it out of the hands of the local zoning board and we're just going to change the zoning code. And anytime you want a permit, you have to pay a certain amount of impact fees or utility fees, not connected to anything, just pay me. And that also should be unconstitutional. And that also should apply the same way that applies for permits. So Paul has a fantastic case called George Sheets, where the property owner he wanted to build a residential home. To be honest, I'm forgetting what town at the moment, but they said, okay, no problem. You have to pay $23,900. And he said, no. Well, actually, no, he paid it. And he said, now give me my money back because that's unconstitutional, which it is. So Paul fought it, and he fought it all the way up. And eventually the case went up to the U.S. Supreme Court. And when it went up to the U.S. Supreme Court, we joined Paul in his effort. But Paul argued it, and he was phenomenal. And actually, in this line of takings, in this line of unconstitutional conditions, there is a prior case, a very hard-fought, difficult case that Paul won when he was at Pacific Legal Foundation with a Pacific Legal Foundation attorney named Brian Hodges. So Paul and Brian won it. It's called Kuntz. So now Sheets comes around and Paul takes it up to the Supreme Court, and he teamed up with us and Brian again. So does Paul and Brian part two. Paul argued the case in front of the Supreme Court in late January. I want to say January 26th. And we're waiting on a decision. You never know till the decision is issued, so I don't want to jinx it. But from the arguments, it seemed pretty good to me. I felt positive about how the arguments went. Paul did a fantastic job, as he always does. But, I don't want to say more till we get it.
All right. And some of our viewers might be wondering, why are we talking about New York City? We're on the West Coast. So
Of course.
why is this important how could this impact us here in California?
Yeah, of course. Of course. Well, this is actually one of the reasons why Pacific Legal Foundation, why we always aim to bring our cases up to the U.S. Supreme Court, because when a case goes up there, the court is resolving a constitutional principle that affects everybody in the entire country. So whether, if the New York case goes up, what they say constitutionally about the New York rent control case would apply to everyone in the nation and every rent control statute in the nation, including California. And the same way, if we were to take a California case up, and Paul's California case is going to affect everybody in the nation, because what the court will say is, if you do A, B, and C, it is unconstitutional. And every statute in the country that does A, B, and C is now going to have to change, including California and Texas and New York and Idaho and wherever. So that's one of the reasons why we aim for the Supreme Court and others do, because for important issues of property rights, you can affect comprehensive national change across a wide spectrum of statutes and states.
Now, one question that I get a lot is, how is rent control not a takings? How is this not a takings? And so for people that just read, read the Constitution, read the amendment, it just seems like, how could it not be? What would you say?
Yeah, it is. I agree with you. I agree with you. It is. It's one of the things that you come to sort of learn and figure out the more you do work that focuses on the Supreme Court is, they're just people, and sometimes, the decisions they make are not always the best. And sometimes when they have competing interests, they don't always do things in the best way. And this rent control, it kind of falls under this: when is the taking of your right to use your property a regulatory taking? And what the Supreme Court does is, they try not to do like the little things. They try to do a grand pronouncement to affect everything in the whole country globally. And then they said, like, let the trial courts figure out what to do with it. And one of the things they were thinking of was, they said, okay, here's what we want to achieve. In some cases, we want it to be a taking. When they take your right to use your property, it should be a taking. But at the same time, we don't want every single thing under the sun to be a taking. Just because the government down zones or has a setback requirement or changes you from, retail to office, they don't want every little zoning thing to require the government to pay a whole bunch of people. So to try to balance that out, they made this 3-part test: economic impact and investment-backed expectations and character. And they thought at the time that, hey, this will work out. But in practice, what has happened over time is the test is terrible and it doesn't work. And a lot of the Supreme Court justices have said, yeah, it doesn't work. This is dumb. We want to revisit it. Justice Clarence Thomas particularly said it a couple times. So they have a not great, I guess to give a long answer and now a short answer to it, it absolutely is a taking. But the reason why it hasn't been is because they have this weird, wonky, difficult to interpret test, and they haven't figured out or had the appetite to fix it because they don't know what to fix it with. Because they still need to be able to figure out, okay, when does the government have to pony up taxpayer dollars and pay you? And we want you to be able to do it when you're really hurt, but we don't want to do it every time you put in a setback requirement. And they just haven't really had the appetite to fix it. It's kind of a broken law. And that's really it. I probably just said it's a broken law to start with. That would have saved everybody 10 minutes. But one of the things I'm focusing on and other people are focusing on is, all right, let's do a new test, and here's what I think the new test should be, and this will fix everything and make it better. But we have to get up there to fix the broken law.
Right. And so it sounds like, obviously you said that they're looking for something that's going to apply to a whole state or a whole the laws applying to an entire municipality.
Hmm.
So what is it? What do you think they need to see? Do you see current laws on the books anywhere in any state that would kind of be like, well, yeah, this one right here, this is the one that we should bring up. Do you see that?
I do, I actually think that this the there's a good part and a bad part to this. I think there are a lot of laws that are that way. And there are a lot of laws that have the capability to really hurt owners and also the capability, though, conversely, to bring about a tremendous amount of change. Um, and here's like the good and the bad part. I think the strongest thing that we have to bring about change are motivated and dedicated people. People who are willing to fight for their rights and fight for their property rights and say, I would like to bring about change. I would like to do this. And a lot of times, when you bring cases up to the Supreme Court, what is compelling to them is not just the law, but the people and how it's impacting people. And when laws have really negative, terrible impacts on people, and they see that and they understand that, it's a very compelling and powerful reason to bring about national change. But the bad part about all of that is that in order to get there, um, there are going to be unfortunate property owners who are going to suffer unfortunate and compelling problems as a result of these horrible laws. And kind of that's the bad part of it, is that, I wish we could just say, this is going to hurt us, but it hasn't yet. Please take this case. But what is most compelling to the Supreme Court is this is really killing this person and this organization, and here's why. So, I think that there are a tremendous amount of bad laws out there and bad rent controls out there that are causing tremendous damage to a wide range of property owners. And it's just a matter of, some of those property owners, coming forth and trying to be the change to get that fixed.
Yeah, right. We have a few people commenting. There's in Pasadena, there's a measure H that they have, and there's they created a rent control board, and there's really not any representation of rental property owners on the board, and they're kind of like a law unto themselves. So they're just mentioning that. Another person mentioning LA City rent control. There's all over the state, the caps, 3% cap, and gosh, it's like when inflation runs wild, you are upside down. And
Mm-hmm.
how can this continue? So maybe if there was incredible inflation, then a point could be made across the board, but we're talking about a massive failure of the system. It almost would take a failure of the whole system before they'd even see actually look at a case. And we can't wait that long. And I know I'm preaching to the choir here in a sense that I know we're on the same page.
Yeah, it's tremendous. I mean, I actually think, unfortunately, there are a lot of locales where being pro-tenant is the politically smart choice. And, from that has arisen a tremendous amount of very pro-tenant laws, which make it incredibly different on property owners. Um, Most of which, I mean, the majority of owners who have rental property units are mom and pops. They're not massive corporations that have tons of money. They're people who need the rent to make their mortgage. But, you know, at least what is good about it is that individuals can bring about change. The same way that, Paul Beard, in his case, his client is George Sheets. And George, this one person by himself, he is taking a case up to the U.S. Supreme Court that is going to result in change for everybody. So at least, there is that, and there is that part of it that, individuals who are, suffering or in bad bad situations because of an existing law can, have the opportunity to do something themselves to bring about change to help everybody. So there's at least that. It doesn't, make the suffering any less, but, change is possible.
Great. And at the bottom, they have, it's probably your phone number, the 916 phone number. Is that your?
Yes, the 916
Yeah,
number.
so
That's
people
my.
will be calling you. They have pacificlegal.org there along the bottom, so people know how to get a hold. And really the purpose that I wanted to share this with our members is for you guys just to understand what just happened, what we're looking for, kind of understand more about it, but also be exposed to Pacific Legal Foundation. There's some of you that need to, that you really should make a donation there. And so I want to encourage you. We endorse them, and the AOA Political Action Committee, we've given to Pacific Legal Foundation in the past. And so that's a good group that we would say, go ahead, that please give money there for sure. And then also just on a state level here, we have a thing called Justice for Renters. I don't know if you've heard of it, John, but they want to repeal Costa-Hawkins. And I don't know how familiar you are with California law,
More than I used to be.
Uh-huh. Yeah.
But that one off the top of my head, I don't know. But the more I learn, the crazier California gets.
Right. So it's basically vacancy decontrol, which would be crazy. And so what we've done is this is the third time that it's come up on the ballot. They spend the money to get the signatures to repeal Costa-Hawkins, and then 2 times it has not worked. What we've done is that sign actually right there is something that we mailed out to every single member of AOA. We mailed it out to every single property management company, and we said, hey, we're going to give you these for free. Put them up in the yard and make conversation with people and share it with your friends. And our people would come to the office and pick up 10 signs or more, or we'd mail them out. And so that's something that we've done, and that's something that we're going to do this time. And anyway, so there's so much to go. There's so much going on, and the national stage is important. And I'm glad that you guys are right there in so many ways. Amazing. 3 different cases last year alone. That's incredible.
Yeah, it's really fantastic. And Pacific Legal Foundation is really, and I can say this only having joined a couple of years ago myself. It's a tremendous organization. The culture and collegiality are wonderful, and it is by far the smartest group of people I've ever worked with. It's really something.
Awesome. Well, there you go, everybody. You got to take action. If we don't want to just sleep, we have to do something. So please do something if you can. And anyway, thank you, John, for the time that you spent just explaining all of that to us.
Yeah, thank you for the opportunity to talk to everybody. This was great.
All right. Take care, everybody.